Hello students, in lecture number 2 we had discussed the definition of the term contract, and according to the definition an agreement which is enforceable by law is called contract. Okay, but how an agreement will be enforceable by law is laid down under section number 10 of the Indian Contract Act 1872. So this can be regarded as essentials of a valid contract. So in this video, I am going to discuss with you that what are those various essentials by which an agreement becomes a valid contract. Now let us start the video. So the essentials of the valid contract has been laid down in section number 10. And according to section 10 of the Act, all agreements are contract if they are made by free consent. If the agreement is made by free consent, it becomes the contract. But if it is not made by free consent, then that agreement cannot be regarded as a valid contract. And it must be made between the parties who are competent to contract. That means to say, the parties to the agreement must be competent to contract, and the agreement must have been made for a lawful consideration and with a lawful object. That means to say, the consideration involved in the agreement should be lawful, it should not be unlawful, and the object involved in the agreement must also be lawful. And it is most important that the agreement should not be declared void under the provisions of Indian Contract Act 1872, because if it is expressly declared void under the conditions mentioned in various sections of this act, then those agreement, even though fulfill all the other conditions, will remain to be void. So I want to repeat it. According to section 10 of the act, all agreements are contracts if they are made by free consent of the parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. So let us study now what is stated in the bare language of section number 10. Let us start. Section 10 states what agreements are contract. In para number 1, it lays down the general conditions by which an agreement becomes the contract, and in para number 2, it describes regarding the laws which prescribe any special conditions by which any agreement becomes the contract. So let us study the first para. All agreements are contracts if they are made by the free consent of the parties, and the parties must be competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. Okay, if all these elements are fulfilled in any agreement, then that agreement must become the contract. But nothing herein contained shall affect any law in force in India, and not hereby expressly repealed, by which any contract is required to be made in writing or in the presence of witnesses, or any law relating to registration of documents. That means to say that if in any law which is not repealed and which is in force in the territory of India, any contract is required to be made in writing, then that contract should be in writing. If any contract says, if any law says that the contract should be executed in the presence of the witnesses, then it should be attested in the presence of the witnesses. Or if any law provides that a document should be registered, then the document must be registered. If it will not be happened, it will not become the contract. The agreement will be void due to the technicalities. So section number 10 is very much clear. that it says about two things. First of all, it says about the general condition in para number 1, and secondly, it prescribe the conditions which are given in any particular law relating to attestation, relating to writing, or relating to registration of documents. So now let us study the essentials of the contract one by one. First essential is that there must be an agreement. In order to constitute a valid contract, there must be an agreement between the parties in existence. An agreement requires two parties for its formation, in which one party gives the offer to the other person and the other person accepts the offer, then an agreement comes into existence. It is very important that the offer must be lawful offer and definite, and the acceptance to the offer must be absolute and unconditional. That means to say, acceptance to the offer must be as such and without any condition on the part of the acceptor. If it is so, then the agreement will be enforceable as a contract. So first condition is that there must be an agreement, and the second condition is that there must be free consent of the parties. But before studying about the free consent, it is very important for us to know what is the meaning of consent. Consent means when two parties of an agreement agreed upon the same thing in the same sense. That means to say there should be consensus ad idem. Consensus ad idem means agreed upon the same thing in the same sense. For example, A is the owner of two houses. Okay, A is the owner of two houses, and that house are house X and house Y. A offers to sell his house X to B for a sum of rupees 10 lakh. Okay, B accept the offer, but what he was thinking? He was thinking that A is selling his house to Y. But what is the reality? He is not selling his house Y. He is giving the offer to sell his house X, not the house Y. In this case, there is no consent between A and B, as there is no consensus ad idem. That means to say they are not agree upon the same thing in the same sense. So no contract can be formed in this case. And a consent is said to be free when it is not caused by coercion. Coercion means it should not be made under any threat. It should not be made under any undue influence, fraud, misrepresentation, or mistake. It simply means that the parties to the agreement must enter into the contract without any type of pressure, whether physical or mental. If the consent of party has been obtained by unfair means, that means either by coercion, undue influence, fraud, misrepresentation, or mistake. Okay, if the consent of any party to the agreement has been obtained by unfair means, then the contract becomes voidable. It simply means that the aggrieved party can avoid the contract by making a civil suit in the civil court for a declaration that his consent had been taken by unfair means, and that unfair means may be coercion, undue influence, fraud, misrepresentation, or mistake, and court on proof of unfair means can declare the contract as being void. But it is very important that the aggrieved party should file the civil suit for getting a declaration that his consent had been taken by undue influence, mistake, coercion, or any other unfair means. But if the aggrieved party do not make any civil suit for getting the aforesaid declaration, then what will be happen? Then the contract remains valid. Okay, then the contract remains valid and both the parties will remain liable for the performance of the contract. Let us take an example. A threatened to shoot B if B does not sell his house to him at rupees 50,000. And B, under the threat of A, agreed to sell his house at rupees 50,000. Here the agreement is entered into under caution and hence is voidable at the option of B. Okay, so second element is also covered, which is free consent. First of all, there must be an agreement and that agreement must be entered by the free consent of the parties, and parties must be competent to enter into the contract. Parties to an agreement must be competent to enter into a valid contract. It implies that parties to an agreement must be of the age of majority. That means to say the minimum age for entering into the contract must be 18 years or more than 18 years. The parties to the contract must be of a sound mind and should not be disqualified by law from entering into a contract. But in case any of the above condition is not satisfied by any of the parties, that means they are not major, if the parties are not sound mind, if the parties are disqualified by law from entering into the contract, then what will happen? Then the agreement would become void. Void means it shall not be enforceable in law. So I want to repeat it again. Who are not competent to contract? First of all, minor is not competent to enter into the contract, person of unsound mind, and person who is disqualified by law from contracting. And fourth condition is that there must be lawful consideration involved in the case. If consideration is lawful, then the agreement becomes the contract, otherwise not. But what is the meaning of consideration? Consideration means something in return. The parties to an agreement must give something and must get something in return. Okay, both the parties to the agreement must give something to the other party and must get something in return from the other party, because an agreement which is without any consideration is not enforceable by law. The consideration may be the past consideration, present consideration, and future consideration. All types of considerations are valid, but it must not be unlawful, immoral, or opposed to the public policy. Let us take example when the consideration is unlawful, immoral, or opposed to the public policy. First of all, take the example of when the consideration is unlawful. A agreed to sell narcotics to B for a sum of rupees 50,000. Okay, in this case, the narcotics is the unlawful consideration. Okay, this agreement is not valid because the consideration involved in this case is unlawful. And what is the example of immoral consideration? An agreement for letting a house to a prostitute for carrying on her vocation there is not valid because the consideration is immoral in this case, as letting a house to a prostitute for carrying on her vacation is immoral in nature, which is dangerous to the society, and the consideration must not be opposed to the public policy. So if there is a trading with an alien enemy, agreement in restraint of marriage, trade, legal proceeding, these are some examples which are opposed to the public policy. If the constitution involved in this case is such a type of constitution which is opposed to the public policy, then the agreement will not become the contract. Now the fifth element by which an agreement becomes the contract is that lawful object. But what is the meaning of object? Object means the purpose or design. The purpose or design for entering into the contract. What was the purpose to enter into the agreement? The object of the agreement must be legal. If the object of the agreement is not legal, it is illegal, then that type of agreement cannot become the contract. For example, A and B makes an agreement for smuggling It means the object of smuggling is unlawful, it is opposed or illegal because the purpose of this agreement it is to escape the liability to pay tax to the government authorities. A and B makes an agreement for smuggling out some goods from India to another country. This agreement cannot be enforced in the court because the object of the agreement is unlawful. And this is also very important that the agreement should not be declared expressly void. If it is declared expressly void, then that agreement will remain to be unenforceable even though parties to the agreement agree on the same thing in the same sense, and both the parties of such type of agreement cannot sue each other because law itself declared this type of agreement void. An agreement must not be one which is expressly declared void under the law. For example, agreement in restraint of trade, marriage, or legal proceedings are such type of agreement which are expressly declared void under the Indian Contract Act 1872 and hence not enforceable. Such agreement remains unenforceable even if the parties to the agreement are at idem. That means they agree on the same thing in the same sense. The aggrieved party cannot seek any relief from the court of law in case of these types of agreements. There must be an intention of the parties to create a legal relationship between them. That is, the parties to the agreement must have an intention of creating legal relationship among themselves. If there will be such a type of intention, then the agreement becomes the contract. But if the parties have not any intention of creating legal obligation with each other, then that agreement cannot become the contract. An agreement which is purely domestic or social nature is not a contract. Why? Because in these type of agreements, there is no intention of the parties to create any legal relations with each other. Let us take two examples one by one. In first example, A invite his friend B to his birthday party. A ने अपने बी फ्रेंड को इनवाइट किया अपने बर्थडे पार्टी पर. B accept the offer, but he fails to turn up for the party. This agreement cannot be enforced in the court of law because the parties had not any intention to create legal relationship. Let us take another example also. A borrows a sum of rupees 1 lakh from his friend B for 3 months. B gets legal right to sue upon A if he means A fails to return money after 3 months. Why it is so? It is because this agreement creates the legal relationship between the parties to the agreement, which can be enforced in the court of law. Let us take an case study. It is a Balfour versus Balfour 1990 का केस है. In this case, a husband just makes a promise to pay. He was just making a promise to pay his wife monthly allowance of £30 for her maintenance. Later on, both husband and wife separated from each other, and the husband failed to pay stipulated amount to his wife. Thereafter, the wife filed a suit for a debt allowance which was promised by the husband, but it was held by the court that such arrangements are not contracts because parties did not intend to create legal relationship, and finally the suit was dismissed from the court. And this is also a very important condition, that the terms of the agreement must be certain. It must be very clear that what are the various terms of the agreement, because if the terms of the agreement are vague, then in that time the agreement cannot be enforced. For example, A agrees to sell 100 books of LL.B Class to B. This agreement is not certain because as it does not specify the type of book to be sold, whether it is of IPC, contract, it has not been specified. There was not any certainty in this agreement. Since the agreement is uncertain, so it cannot be enforced in the court of law. The ninth condition is very important. The agreement must be such which is possible to perform. If the act which is agreed to be performed is impossible to perform, then the agreement will become void. There must be possibility of performance in the agreement. An agreement to do an impossible act in itself is void. For example, an agreement to double the wealth by magic is void because it is impossible that wealth of a person can be made double by a magic. Apart from the above 9 conditions, if in any particular law there are some legal formalities which are required to be fulfilled, then those legal formalities must be fulfilled to convert an agreement into the contract. Because if those legal formalities which are required to be fulfilled in any particular law are not fulfilled, then the agreement becomes unenforceable on technical grounds. Okay, an agreement is required to fulfill all the legal formalities, otherwise it becomes unenforceable on technical grounds. An agreement should be in writing in case of lease, gift, sale and mortgage of immovable property, etc. Sometimes the law requires that the particular document should be stamped of a particular amount. Then, unless and until that document will not be properly stamped, it remains to be unenforceable. And in certain laws, some documents are required to be registered. So, if there is such type of requirement of registration of the document, then the document must be registered. After the completion of all the legal formalities, an agreement becomes the contract. So in the end, it can be concluded that every contract is an agreement. Every contract is an agreement, but all the agreements are not contract, because an agreement to become the contract has to fulfill the above stated 10 conditions. So this is something about this lecture. Thank you very much.